A direction to the respondent to undergo for a medical test, proving herself that she is an impotent. Because
Yes,
seeking for a decree of nullity of marriage on the ground that the respondent is an impotent.
So that
Please.
you will say that she is impotent,
Please, Milord.
and you will send her to the medical test, and basing on that medical test, you will prove.
Please, Milord. In this matter, Milord, there is no cohabitation at all. Since from the beginning, Milord, the respondent, Milord, not even allowed to take the respondent. The petitioner not even touched her. There is no ceremony. Even the ceremony is conducted, she was refused.
Yes.
From the beginning, Milord, the entire pleadings of the petition is very clear. That is the reason, Milord. That is the reason the petition, Milord, instituted for seeking for a decree of nullity for not divorce.
Understood.
When a petition is being filed under Section 12, Milord, for seeking for nullity of marriage, Milord,
So
unless there is a Milord, medical evidence, Milord, I can't prove, Milord, she is impotent. Because Milord
wanted a divorce. Since as per Act is not, there is a embargo that within 1 year you can't file petition, they filed this petition for nullity of the marriage. So kindly come to this. The respondent on 5/12/2015 has taken to gynecologist Dr. Lata at Pragati Clinic, which is situated at Chikka Alessandra, Bangalore, for consultation. Even to the aforementioned doctor also, the respondent has not allowed her to test and to make preliminary inquiries. The doctor expressed that some counselling is necessary and detailed examination is required from the reputed doctors to test the maturity or otherwise health condition of the respondent. So kindly come to
husband petition, Milord, challenging the orders of the trial court, wherein, Milord, an application filed by the husband, who is the petition before the trial court, is dismissed. The application, Milord, sought for a direction to the respondent to undergo for a medical test, proving herself that she is an impotent. Because, Milord, the petition is filed under Section 12 of 1, saying that, Milord, she is an impotent. The decree of
That's allowed.
that is not allowed. The original petition is filed before the trial court.
For the
Husband, Milord.
yes,
He filed a petition under Section 12(1), Milord,
yes,
seeking for a decree of nullity of marriage on the ground that, Milord, the respondent is an impotent. During the pendency of the proceedings, Milord, he filed an application seeking for a direct the wife respondent to undergo for a medical test to prove that, Milord, she is capable to get married. That came to be rejected, Milord.
How this memo is moved? What is the urgency for that?
Milord, Milord, got married in the year of 2015. Matter, Milord, was laid before the trial court for 9 years. She has filed, Milord, against me a domestic violence. She has also prosecuted me under 498.
You also filed this petition of 2023.
Milord, the application itself is rejected in the, Milord, 2023.
We will pass orders. Please come to the order.
Lordship may kindly see.
Yes. Now that you will say that she is impotent,
Please, Milord.
and you will send her to the medical test, and basing on that medical test, you will prove.
Please, Milord.
Yes.
Go to first judgment, Milord. It is very clear, Milord, from the Supreme Court. It is held 2003-4 Supreme.
Para of 2003 judgment.
Please, Milord.
Sharada Dharmapal.
Please, Milord. Para number, Milord, 76, Milord.
Para 70.
Please. Married, Milord.
Yes.
Running page number 31, Milord.
Yes.
The matter may be considered from another angle. In all such matrimonial cases where divorce is sought, say on the ground of impotency, schizophrenia, etc., normally without there being any medical examination, it would be difficult to arrive at a conclusion as to whether the allegation made by a spouse against the other spouse seeking divorce on such a ground is correct or not. In order to substantiate such allegation, the petitioner would always insist on medical examination. If the respondent avoids such medical examination on the ground that it violates his or her right to privacy, or for that matter, right to personal liberty as enshrined under Article 21 of the Constitution of India, then it may in most of such cases become impossible to arrive at a conclusion. It may render the very grounds on which divorce is permissible negatory. Therefore, when there is no right to privacy specifically confirmed by Article 21 of the Constitution of India, and with extensive interpretation of the phrase personal liberty, this right has been read into Article 21. It cannot be treated as an absolute right. What is emphasized is that some limitations on the right have to be imposed on particularly where two competing interests clash in matters of the aforesaid nature, where the legislature has conferred a right upon his spouse to seek divorce on such grounds.
Please come to para 78.
78, my lord. It is, however, axiomatic that a court shall not order a roving inquiry. It must have sufficient materials before it to enable it to exercise its discretion. Exercise of such discretion would be subject to the supervisory jurisdiction of the High Court in terms of Section 115 of the Code of Civil Procedure and Article 227 of the Constitution of India. Abuse of the discretionary power at the hands of a court is not expected. The court must arrive at a finding that the applicant has established a strong prima facie case before passing such an order. In this matter, my lord, there is no cohabitation at all. Since from the beginning, my lord, the respondent, my lord, not even allowed to take the respondent. The petitioner not even touched her. There is no ceremony. Even the ceremony is conducted, she was refused.
Yes.
From the beginning. The entire pleadings of the petition is very clear. That is the reason, my lord. That is the reason the petition, my lord, instituted for seeking for a decree of nullity for not divorce.
Understood. Yes, next.
Next, my lord. Next para, my lord.
Palani Swami.
17
I've seen
and-
the judgment. I've read the judgment.
Next, I may request my-
70?
the next para, my lord. The next para.
Yes.
And the very same judgment. If despite an order passed by the court, a person refuses to submit himself to such medical examination, a strong case for drawing an adverse inference would be made out. Section 114 of Indian Evidence Act also enables a court. So,
First is you should make out a prima facie case.
please, my lord.
Court should be satisfied
Please,
while
my lord.
exercising a jurisdiction of 115 or
Please,
227
my lord.
that you have made out a case.
Please, my lord.
Then the court will order for that.
Please,
If the other person refuses it,
Please,
then the question of adverse
Please, my
inference. So now the whole question is, have you passed on those steps?
please, my
The
lord.
question, at what time you have filed this application?
This application is being filed.
Just you file your case and immediately you file an application. Is it a case that there is you have already made out a prima facie case?
My lord, when
No.
a petition is being filed under Section 12, my lord, for seeking for nullity of marriage, my lord,
So
unless,
every
my lord, unless
person,
there is my lord, medical evidence, my lord, I can't prove my lord she is impotent. Because my lord, it is an arranged marriage. She is also stranger. My lord, marriage has taken place in the year of 2015 itself.
Yes.
My lord, there is no cohabitation at all between the parties. My lord, how, my lord, under what material, my lord, what can expect me to produce, my lord, before the court to demonstrate that, my lord, she is impotent or not impotent, my lord. Only, my lord, by way of medical evidence, it can be, my lord, examined.
yes,
Next matter, my lord.
Palani Swami, which para?
My lord, this Palani Swami judgment, my lord, I have produced only for the reason, my lord, before the trial court, they have, my lord, raised an objection, saying that, my lord, there is no provision, my lord, seeking for a medical examination. And there is a error in the provision. That is the only reason, my lord, I have produced that, my lord.
That
Even
is
the
not
error, my
nec-
lord,
that
can be
is not
neglected.
nec- that is
That is
not
the only
necessary.
reason.
Yes, next judgment.
Next judgment, my lord,
Zahida Begum.
Zahida Begum.
Hmm.
Para number 3, 4, and 5, my lord. Married, my lord.
Yes,
Page number 48, running page 48, my lord. I
yes,
have been taken through the impugned order with the assistance of the learned counsel appearing for the petitioner. It is no doubt true that directing either of the parties to undergo medical test in the circumstances is certainly warranted. The question is whether the defendant should be subjected to medical test or the plaintiff also should be subjected to identical test. It is to be noted that the specific case made out by the plaintiff petitioner is that the marriage could not be consummated as the defendant respondent was impotent and he was unable to perform the matrimonial obligations in the circumstances. The question whether the plaintiff petition is virgin or is not a wholly unnecessary. In the circumstances, the learned trial judge would not have directed the plaintiff petitioner to undergo virginity test at the hands of the so and so. The question whether right of privacy is invaded in the matrimonial case where the parties are subjected to medical test has
those
been set.
judgments are referred to in this. The earlier judgments are referred to.
Even in the
Sharada's
order-
case and all
Even in the order, it has been reflected, my lord. All these judgments have been.
in this judgment.
Lord, the para number 5 is very clear in this order.
Hmm.
The order directing the defendant respondent to undergo medical test at the hands of the heads of so and so Kim's Hubli regarding potency is maintained. The order directing plaintiff petitioner to undergo virginity test is on so and so is set aside. My lord, it is
Yes.
permissible.
Yeah.
Next, my lord. Shiva Dayal.
Not Shivadaya. Next is Madhya Pradesh High Court judgment.
Please, my lord. Shiva Dayal. Oh, sorry, I'm sorry, my lord. Shantabai, my lord.
Hmm.
That is, my lord, running page number 53, para number 6, my lord.
Hmm.
On the bottom, last 2 lines.
Yes,
whether it is found that after a reasonable time of marriage, there could be no copulation in spite of opportunity.
Are you reading para 6 or para 8?
6, my lord.
It starts with Srimati Shanti Bai.
And the last 2 lines, my lord.
After 1 month, she went back to her matrimonial home.
The basis on which, that is para number 5, my lord.
Para number?
That is in para number 10, out of that point number 6 in the last line. 53, last 2 lines.
The finding is at para number 11.
Please, my lord.
Applying these tests to the present case.
Before that, my lord, I would like to read, my lord, that point number 6 in page number 53, bottom of the 2 lines, right side corner. Last, my lord, 6 in bracket. Running page number 53, my lord. On the bottom right side, last 2 lines. May I read, my lord? Whether it is found that after a reasonable time of marriage, there could be no copulation in spite of opportunities because the other party refused to intercourse and resisted all attempts by the husband without just cause, the court would be right to conclude that the refusal arose from the incapacity to consummate the marriage.
I'm not able to find where are you reading. Are you reading this judgment of Madhya Pradesh AR 1966
Please, my
Madhya
lord.
Pradesh?
Please, my lord. That is, my lord.
Paras are very clear. Why this confusion?
My lord, para number 10, my lord. Page number 12, 53, 10.
Legal position on impotency.
The
is
2
does
legal
not
position
install.
impotency is in the very same para, last bottom second line from the bottom.
Whether it is found that after
Please, my lord,
reasonable.
please,
Yes.
please, my lord.
No,
Whether
if
it
you
is-
say 6 in 10.10, the para number 10.
Point number
people
6 in
understand.
para number 10, my lord, please.
Yes.
Whether it is found that after a reasonable time of marriage, there could be no copulation in spite of opportunities because the other party refused to intercourse and resisted all attempts by the husband without just cause, the court would be right to conclude that the refusal arose from the incapacity to consummate the marriage. Applying these 11, my lord, I'm reading 11.
Yes.
Applying these tests to the present case, in having given our anxious consideration to all the facts and circumstances, we have come to the conclusion that although the appellant is not structurally or psychologically incapable of allowing sexual intercourse generally, yet she has an uncontrollable aversion to allowing the courts to the petition husband. This case belongs to a rare variety of frigidity, quad hank, and we further find that such unconquerable aversion to the consummation of marriage existed at the time of marriage and has been in existence continuously. We are satisfied that these proceedings have been free from collusion. The parties appeared before us.
No,
endeavor-
once you have a judgment of the apex court, then
Please.
why do you want to rely on the judgments?
Please, my lord.
Yes.
All the judgments are following the very same, my lord. My lord, my respectful submission before the Dismissal court is, my lord. My lord, she was with me for very particular period of very short period. My lord, she never allowed me to touch her. And my lord, there is no cohabitation between the parties, my lord, according to me in my petition aversion. My lord, when such being the case, my lord, the husband cannot be expected to demonstrate or produce any document, prima facie document before the court to show that, my lord, she is impotent. Unless, my lord, there is a medical examination, my lord, by way of, my lord, order of the court. My lord, I can't demonstrate before the court. That is my grievance, my lord.
But the petition has been filed on 4/1/2016, man.
4-1.
2016.
You said 5/8/2016.
4/1/2016 was the date when the
That is after 6 months of marriage.
marriage.
Hmm.
So they had issued a notice to me on 26/12/2015.
26/12/2015.
Within 8-9 days, they filed the petition without even waiting for my reply to replying the notice. They filed the petition. Subsequently, the first week of January 2016, I filed the reply notice. We issued the reply notice to their notice, which is dated 26/12/2015.
Reply is when?
So first week of January 2016. By
First
that
week
time,
means what is the date?
it is 7th month, 7/1/2016. They had filed the petition on 4/1/2016 itself. Now, my lord, the marriage has happened on taken place on 11/6/2015, my lord. 11/6/2015. The first nuptial ceremony has happened on 20/11/2015. 11/2015. So subsequently, they started to live together, man, as husband and wife. For my submission, is the marriage has been consummated. First submission. The second submission is, my lord, this petitioner wanted a divorce, man. since as per Act is not, there is a embargo that within 1 year you can't file petition, they filed this petition for nullity of the marriage. So kindly come to para 8 of the petition, madam, which is at page number 30. Sorry, page 21, madam. Para 8 of the petition before the trial court. We permit to read this one, madam.
Yes,
The petition further submits
yes.
that during her stay at his residence, the respondent on 5/12/2015 has taken to gynecologist Dr. Lata at Pragati Clinic, which is situated at Chikka Alasandra, Bangalore, for consultation. Even to the aforementioned doctor also, the respondent has not allowed her to test and to make preliminary inquiries. The doctor expressed that some counselling is necessary and detailed examination is required from the reputed doctors to test the maturity or otherwise health condition of the respondent. Now, kindly come to page 30, objection statement which the respondent has filed before the trial court. Para number 11. Be permitted to read this particular para. In that one, there is contrary around after 8 lines in the middle of the paragraph. Contrary to the above, the petitioner had forcibly, by misleading and manhandling the respondent without any intimation to her parents or to anyone, had taken to the said doctor, who is not a gynecologist but is just a physician without any specialization, and the said doctor tried to make physical examination against the wishes of the respondent as regards to her bodily composition or her femininity, and the said doctor forcibly conducted the examinations and had declared that the respondent is hale and healthy and has no health issues, and her femininity and bodily composition is normal as like any other woman, and the said doctor had never prescribed any medicine or counselling or further examination as alleged. The above clearly demonstrate the sadistic attitude, nature and character of the petitioner towards the respondent. My lord, there is a document in his custody, my lord. Till date, he has not produced the document and has not laid the evidence. He has to prima facie prove his case. Until unless that is proved, this application is premature and it cannot be considered.
Please come. Agreed with the orders passed in I number 4 in MC number 56 of 2016, dated by so and so, but dated 2nd February 2023. The husband is before this court. The husband had filed the number 56 of 2016. Seeking to declare the marriage as nullity, as the wife is not a competent person to consummate the marriage, as per the averments of the petition that is filed, seeking to declare the marriage as nullity. It is the case that the marriage has taken place on 11/6/2015. And after the marriage, the wife had came to the house of the husband and stayed for 1 day, and immediately left her parents' house. It is the case of the husband that the wife had not shown any interest or affection towards the husband, and the marriage is not consummated. Within a few days, the husband searched a rented house and informed the respondent to join the company of the husband. The wife and her parents put forth unnecessary conditions that the aged mother of the husband should not be with them, and the relatives of the husband should not come to the rented premises, so on and so forth, as a condition to join the matrimonial home. The respondent, the wife had not joined, and whenever he approaches the wife by going to her parents' house, she has not expressed any kind of interest in him and not allowing him to come near to her. The husband had made all his best efforts. It is his case that the wife is calling him during his office hours and abusing for the unknown reasons. It is stated that on 1/11/2015, there was mediation held at JP Nagar, at the relative space of the husband, where the parents and the wife and the parents agreed to send her to the house of the house of the husband. And it was also decided to perform the nuptials on 20/11/2015. A condition that with a condition they imposed a condition that the relatives of the husband should not be attend the function. And a small function was held on 20/11/2015. According to him, there was no the marriage could not be consummated. It is also stated that on 5/12/2015, he had taken her to a gynecologist, Dr. Lata, at Pragati Clinic, which is situated at Chikkala Sandra, Bangalore, for consultation. And even she has also not permitted the doctor to test her and make a preliminary inquiry. The doctor expressed that some counseling is necessary and detailed examination is required from the reputed doctors to test the maturity or otherwise health condition of the wife. It is also the case of the husband that the wife had developed a kind of insecure feelings and has become very suspicious and tried to test the patience of the husband in different ways. She was talking a lot about the character of the husband, defaming his self-respect. On 22/12/2015, the respondent and her parents came to the house of the wife along with her parents came to the house of the petitioner and started quarreling with him for unknown reasons. And the father of the wife also threatened him with dire consequences. On the day the petitioner went to his house and found the same is locked, and the wife had taken away all the household items, gold rings, silk sarees, and other items to her parents' house. It is stated that on these grounds, as there was no other alternative, he had issued a notice on 26/12/2015 calling upon the wife to give consent for dissolving the marriage. After receiving the notice, she lodged a complaint on 1/1/2016. And he has come up with the present petition seeking to declare the marriage as nullity. The wife had filed her objections to this petition and she has denied the allegations, and according to the wife, the marriage is consummated. It is stated that the husband had forcibly, by misleading and manhandling the wife without any intimation to her parents or to anyone, had taken to Dr. Lata. but who is not a gynecologist, but is just a physician without any specialization. And the doctor tried to make physical examination. It is the wishes of the wife as regards to her bodily composition and her femininity. And the said doctor forcibly conducted the examination and declared that the wife is hale and healthy and has no health issues. And her femininity and bodily composition is normal as like any other woman. And the said doctor had never prescribed any medicine or counseling or further examination. In view of the same, it demonstrates the statistic nature and character of the husband. And along with that, she has taken a stand about the consummation of the marriage and that the petition has to be dismissed. This application, that is I number 4 is filed. Which is the date of the application?
24/11/2016, my lord.
On 24/11/2016, I number 4 is filed. Seeking a direction to the respondent to appear before the competent doctor or gynecologist for medical examination about a physical, psychological capability in consummation of marriage and furnish the report to the court. The trial court, by order impugned, had dismissed the application. The court, while dismissing the application, had observed that the court had relied on a judgment of this court in Regamma versus Shantappa. And observed that in a case where a party alleges that a person is impotent or suffering from other such incurable disease, it is for a person making such an allegation to prove the same. A party cannot be compelled to undergo medical examination. It is also observed that there is no provision in the Hindu Marriage Act or the rules framed thereunder, or in the Code of Civil Procedure, or in the Evidence Act, or any other law which would show any person in the court to compel any party to undergo medical examination. And the court had also considered the judgment of the High Court of Andhra Pradesh in case of Pulavati Sriram Murthy versus Lakshmi Kantamma. And relying on these judgments, the court observed that the marriage of the petition, the marriage is solemnized on 10/6/2015. And according to the petitioner, nuptial ceremony was arranged in the month of November. And at para number 8, the office of pleadings had taken contention that during her stay, during the stay of the wife in his residence, on 5/12/2015, he has taken to the gynecologist. He had not produced any document to that effect to show that whether there any advice is given to the respondent. Dr. Lata is gynecologist, and the wife, her husband himself had taken the wife to the hospital. Therefore, question of issuance of direction to the wife for medical examination do not arise. When the husband has approached the court seeking the declaration that the marriage is a nullity, he has to prove the facts. Therefore, without evidence for both the parties, application filed by the husband is not maintainable, and accordingly dismiss the application. Agreed thereby, the present appeal is filed. And counsel for the petitioner submits that the marriage could not be consummated as the wife is impotent. He has no other way to prove the case except sending the wife for medical examination. Unless and until she is examined and a report is placed before the court, it is difficult for the husband to prove his case. And the trial court, without considering all these aspects, had dismissed the petition. He had relied on the judgment of the apex court in case of Sharada versus Dharmpal, reported in 2003 for SCC 493. He relied on para number 76, 78 and 79, which reads thus, extract all this paragraph. He had also relied on the other judgments of the other high courts, which were passed, taking into consideration the law laid down by the apex court in Sharda versus Dharampal's case. Relying on the said judgment, he submits that the finding of the court is contrary to the certain law, and sending her to a medical examination is not a violative of Article 21 of the Constitution of India, and court had failed to appreciate the contentions put forth and the legal position, and as envisaged by the Honorable Apex Court. That's it.
Please, one more submission, my lord. Whatever the judgment, my lord, relied upon by the trial court, is, my lord, in the Dharmapal's case, my lord, everything is discussed.
Submits that
And, my lord, it is
the judgments
reversed.
that are relied on by the trial court are all considered by the apex court in Sharda versus
Please.
Dharampal's case. And the court ought to have considered the said judgment. Next, learned counsel appearing for the respondent wife submits that the marriage had taken place on 11/6/2015. And the nuptial ceremony was held on 20/11/2015. The marriage is consummated. When a notice was issued on 26/12/2015, they have issued a reply notice on 7/1/2016. Even before the reply is sent, they have filed the petition on 4/1/2016. It is a case of the husband that it is a case of the wife that the husband wanted a divorce, and as they cannot move an application for divorce before 1 year from the date of marriage, he has come up with this application. The learned counsel submits that when according to the husband, he had taken the wife to a doctor by name Lata, a gynecologist, and the wife has been subjected to the examination. In the evidence, he could examine the said doctor, and he can also place before the court the report of the said doctor, as even the wife is admitting in her pleadings that the husband had taken her to the doctor. Learned counsel submits that without making any effort or without even discharging the burden on him, he cannot file an application straight away for subjecting the respondent to the medical examination. It is submitted that the judgment of the apex court, which he is relying on in Sharda versus Dharampal, in fact supports the case of the wife, and the trial court had rightly dismissed the petition, and no grounds are made out seeking interference with the well-considered order passed by the trial court. Next paragraph. Having heard the counsels on either side, there is the material on record. The marriage had taken place on 11/6/2015, and he had filed the application, that is the present MC petition, on 4/1/2016. According to the husband, the marriage is not consummated as the wife is impotent. He has made all his efforts, and it is also his case that he has taken the wife to a gynecologist by name Lata. Even the same was accepted and affirmed by the wife in her objections, stating that she has been taken to the doctor. And according to her, the doctor had, after examination, has felt that by all means, the wife is normal. The husband had not adduced any other evidence, the evidence of the family members or the relatives, or he is also referring in his petition about the mediation that is done. Now, unless and until he makes out a prima facie case wherein with the available evidence that because the wife is reluctant, and in that regard, the mediations were also done, and having no other go, he had to come before the court with an application, with this petition seeking nullity of the marriage, straight away, he cannot come up with an application stating that the wife has to be subjected to the medical examination. The Honorable Apex Court in Sharada versus Dharampal's case had considered the rights of a party and their right to privacy under Article 21, and also the court the right to privacy as enshrined under Article 21 of the Constitution, and also and how it has to be balanced with the right to right of a person to defend himself. The court had observed that when there is no right to privacy specifically conferred by Article 21 of the Constitution of India, and with the extensive interpretation of the phrase personal liberty, this right has been read into Article 21. It cannot be retained as an absolute right. What is emphasized is that some limitation on this right have to be imposed, and particularly where two compelling interests clash in matters of the aforesaid nature, where the legislature has conferred a right upon its spouse to seek divorce on such grounds, it would be the right of that spouse which comes in conflict with the so-called right to privacy of one party. There, the Apex Court has felt that there should be a balance between a right to privacy and at the same time the right of the other person to be adequately defend himself. Then, while laying such a ratio, the Apex Court has also categorically observed that in those cases the court shall not order for a roving inquiry. It must have sufficient material before it to enable it to exercise its discretion, and such discretion would be subject to the supervisory jurisdiction of the High Court in terms of Section 115 and of Article 227 of the Constitution of India. Abuse of the discretionary power at the hands of a court is not expected. The court must arrive at a finding that the applicant has established a strong prima facie case before passing such an order. For applying the ratio laid down in Honorable Apex on the judgment of the Apex Court in Sharada's case, the first and the foremost is the party who seeks such a relief should make out a prima facie case. In this case, what all it is now it appears that it's a case of the petitioner that whatever the averments that are stated in the petition is a prima facie case. In those averments itself, he has stated about the mediation that had taken place. He taking the wife to a doctor. He should put forth his case that by choosing necessary evidence that I'm under, he should make out a prima facie case in that. And in those circumstances, still, if the medical examination is required, and if the court comes to the conclusion that unless and until a medical examination is conducted, the petitioner husband would not be able to prove his case, and having satisfied that there is a prima facie case, then at that stage, either the application or the request that is made by the petitioner for examination can be considered, but it cannot be at a threshold without even adducing any evidence or without even making a prima facie case, a strong prima facie case, where the court will be compelled to ask the respondent to subject herself to the examination. in the considered opinion of this court, the stage at which the application is filed by the husband is not appropriate. And and as on the, while, and you could not make out a strong prima facie case, which can compel the court to pass an order subjecting the respondent to medical examination. In that view of the matter, this court finds no reason to interfere. But however, the liberty is given to the petitioner to file such an application at an appropriate stage.
So number 7, Monisha NS.
Accordingly disposed of.
Monisha NS for petitioner,
rest.
Ravi A. Belagatti,